Good afternoon. Thank you so much for joining us, and thank you for being patient as we had a few things going on the back end. This is a special lunch and learn for us. This is probably the most involved lunch and learn that we've done, as far as things that are going on that we think that people should be aware of. And that is second look bills. So we're going to get into that. I want to do a quick introduction. I'll show a video, and then we'll get into our conversation. I am Sandra Santa Buckles with MCVRC. I am usually your host, trying to break down some of the legalities and technical things, because when you work with a bunch of lawyers, it doesn't make you understand anymore unless you stop and ask. So I am just notorious for doing that, because I do want to understand what's going on, and I hope that you at home want to do the same. And then we'll just round robin here with Joanna, Vic, and Don. Joanna?
Thank you, Sandra. I'm Joanna Mupenduki. I'm the Deputy Director of Maryland Crime Victims Resource Center. I've been an attorney for over 17 years. I've been a prosecutor in Washington, California, the state of Maryland, and also worked for the government in California and the Department of State Hospitals. So that's a little bit about me. Thank you for being here.
Thanks, Joanna. Victor?
Hi, I'm Victor Stone. I spent many years at the U.S. Department of Justice as a criminal prosecutor, and I was both a prosecutor in the federal trial courts, which are called district courts in many different locations, and I also was handling appeals for the government in all of the U.S. federal courts around the country. And I drafted more than a half a dozen U.S. Supreme Court briefs that were filed by the U.S. Solicitor General. I did some other things too, in that I used to be an informal advisor for the Federal Bureau of Prisons. I also defended cases where the United States Parole Commission was being sued. For a while, I was a backup point person as the Department of Justice representative to the U.S. Sentencing Commission. And so I have quite a bit of experience dealing with criminal cases and sentencing.
Perfect. Thanks so much, Victor. And Dawn Collins.
Good afternoon. My name is Dawn Collins. I'm the very proud mother of Lieutenant Richard W. Collins III. Lieutenant Collins was murdered on the campus of the University of Maryland College Park, the flagship university of the state of Maryland. And I cannot express enough the thoughts that I have about victims and survivors of hate.
Thank you, Dawn. And we'll get more into Dawn's story and some of the things that she's been up to shortly. I want to introduce this video of Joy Kingsley Abbey. She was, both her father and her brother were murdered on separate occasions, many years apart. So here's what she has to say.
So I'm back, and the hearing, I guess it was in our favor. I'll say that. We got there. It was at the Maryland Correctional Institution in Jessup, Maryland. So it was about a 45 to an hour drive for us. And it's crazy pulling up into a prison, y'all. It's really wild. And then it just kind of makes you think when you pull in there. You think about the inmates and all the fences and the wires and the guard towers and all of those things. Once they escorted us to the next room, this was a room now that had the one-way mirror. When you watch the shows, everything in my life is about what I see on TV, but whatever. We could see into that room, but they couldn't see into it. So they put my family and our advocate and his attorneys in the other room, and he was there in front of the commissioners at the table where we were just sitting, and so his back was to us. So we saw him walk into the room, saw the back of his head and the side of his profile, and he had a mask on, so we couldn't really see his face, which I really wanted to see him. I really wanted to see the face of the man that murdered my father. And because he's just been this like figment of my imagination, because I have no recollection of his face during the murder trial. But I haven't really found any photos from looking for him online. And he's 60 years old now, so even if I did remember what he looked like, he's almost a completely different person than what I knew. So it was weird, because now I can't unsee like the back of his head, his hair texture, his neck, his beard, his complexion, all of those things. And then now I have a voice. I have a voice to this thing. And I don't know how that's going to affect me yet, but it might, you know. We hear him now talking. They're asking him questions. They go over his criminal record. They go over his prison record. And then they talk about his behavior, you know. So they bring up the infractions, things that he's done while he's in prison, and any programs that he's been in while he's been in prison, and what has helped him out. And the thing I found, the thing that hit me and hit my family while we were listening to him was, I don't know, it was a complete lack of remorse. You literally just heard the 3 children give their victim impact statement. And his answers were more like, oh, well, I've taken this program, I'm a landscaper, I've gotten this degree, I've done this, I've done that, therefore I deserve to be out. But not I deserve to be out, because I've actually sat in here for 39 years and I feel fucking bad about what I did to this family and these poor children and this innocent man. None of that. And then when he was talking about my father, he said the Ibex family, which in my mind, he's thinking it's spelled I-B-E-X, Ibex family. So in 39 years, you couldn't even get the last name right of the man whose life you took, of the family whose life you shattered and broke. And he said it twice. And I will never forget that. And I will remember that when I write my next victim impact statement. So we heard all of that, no remorse. And then they give us a break while the commissioners talk about things, and they take a bunch of notes and blah, blah, blah. And then they bring everyone back. And so now they let us know what their decision is. And they decided to give him another parole hearing in 2 years. So it wasn't a denial, a full denial, I would say. It wasn't a, you're paroled, and it wasn't a hold, but he's in prison, you know, at least for another 2 years. But it wasn't a, I'll take it, we'll take it, you know. And because I like the way the commissioners were asking him questions, because they literally asked the questions that I was thinking. Why did you not do this? Or why did you do this? So I can tell they made a decision based on the facts. Appreciated the way they did things. I appreciated their kindness and their grace. And I appreciate that I think that they took our victim impact statements into high consideration. And that's all we want to know as victims, is that our voices are being heard, and that someone actually cares for us, you know, and what we have gone through. And I felt that today. So we'll be back in 2 years and writing another victim impact statement. And yeah, I went to prison in my green and white suit to represent my dad and represent Nigeria. And I beat my face, and I looked good, because I wanted to show, and this is because I didn't know if he was going to get a chance to see our family, but I wanted him to know that he didn't kill us too, that we are still standing. And despite the hardships that were bestowed upon us because of his heinous actions, my family is still standing. I appreciate it.
Okay. So that was Joy. She could not join us today because she's actually in Nigeria now. So there's some time issues there, although she really wants to make sure that she stands with us. One of the things that she talked about was that the parole commission talked about infractions. And so we wanted to share with you at home what that looks like, right? Because there's a system in place where if you're going up for parole, they look at all of these things. So let me hop to, I know this is such a complex thing that we're doing this time. Oh, did I do this right? Oh, here we go. Okay, let me take this bottom thing off because I feel like we can't see everything. All right, have at it, guys. She talked about infractions. These are the things that the parole commission reviews when talking about, when bringing people to the parole board to see if they're eligible, right? There's a lot of background info on this where we sued the parole commission. You guys can look at our historical stuff where we did that, or if someone's interested, you can reach out and we can talk about that. But we're running short and we want to make sure that you guys get all the information that you need. Vic and Joanna, I'm going to leave this up to you here, and then we'll hop into the actual bills that are going on now.
No, that sounds good. Thank you, Sandra. We wanted to bring this to the front so that everyone can look and see what is the parole commission actually looking at when they release people? Because we do have a system already set up as to determine if people should be let out early on parole. And it's different because the bill we're going to be talking about is talking about going back to court in front of a judge. It's going to be over 20 years since they were they have to have served 20 years of time. So it's not going to be the same judge who saw their trial. Most judges retire after their initial 18-year time as a judge. And so you're going to have a new judge, you're going to have a new prosecutor, you're going to have new defense attorneys. And so the only people who were there at the time of the trial are the defendant, the convicted defendant, who's going to say whatever he can to get out of jail. And I'm going to stop in a moment and let Victor talk about that, because he has certainly represented numerous cases where defendants have come and told a completely separate story than what happened at trial. And only because our victim families were there and saw what happened and can alert them. Now, we've brought this up to the legislature and to the parole commission. They say, oh, well, we can look at transcripts. And it's like, well, yes, but it's very rarely done. Very rarely do they actually print the transcripts and look at them. And so they're not getting, neither the parole commission nor the judges are getting the full information of what happened during a trial. And that's and that whole part. So I'm going to turn it over to Victor to just talk a little bit about these factors, the current push that the parole commission does not want to give as much impact to one of these factors. We do have a pending lawsuit against the parole commission, and then we'll turn it to Dawn for her reaction.
Okay, I think that first I ought to explain that in the 1980s, there were a lot of research studies to see what kind of sentences were being handed out. And when the research came back, dealing with tens of thousands of federal cases, it showed that the average sentence that was being handed out was 4 years. That's how long, on average, people were staying in jail. And the legislators said, wait a minute, how can that be that the average sentence is 4 years? And by the way, 40% of the people being sentenced were sentenced to no time at all, straight probation. So the federal government set up a sentencing commission that looked at all thousands of sentences, tens of thousands of sentences, averaged them out for each crime, and then did a grid where judges could look at the crime committed, what the aggravating factors involving the crime were. For example, did the person carry a weapon, use a weapon? And the individual, did they have prior convictions or not? And using that, try and impose a sentence that was within a 2-year range, give or take 2 years, that made their sentence fair and similar to other offenders across the country. A lot of states realized they were in the same position, and they also enacted sentencing commissions, including the state of Maryland. the Sentencing Commission was there to give judges an idea of what the average sentence was for that kind of offender and that kind of offense. Well, in the meantime, that those sentences were still subject to being shortened by not only credits that inmates automatically receive when they go to prison, which shortens their sentence that the public is not really aware of, and also shortened by the Parole Commission. For example, most people don't know that if a person commits a murder and is sentenced to a life sentence that is parolable, that they're eligible for the Parole Commission to look at them as soon as 11 and a half years in most cases. So in theory, they could be paroled after 11 and a half years, even though they got a life sentence. Most people couldn't imagine that that's the case, but that is the case. Well, the bill that is, well, in a lot of states that adopted these sentencing guidelines for judges, they then said, well, if the judges are sentencing based on guidelines and we have automatic credits for inmates so we know they're going to earn some credits, why do we even need a parole commission? And many states abolished their parole commission altogether. There's no United States Parole Commission for federal crimes anymore. Well, then inmates started to sue and say, well, wait a second, what if we have good behavior? What if we do this? What if we do that? And the answer around the country was, well, you're getting special credits for good behavior. That's all factored in. At any rate,
So you're already getting credit. You're already getting credit for being good. So what do you want?
That's right. There are good
What do you
time
want from
credits that reduce your sentence if you are behaving in prison.
And so I just wanted to tack on that, you know, with Joy's story, it's a much longer entire video, but she talks about some of the infractions that inmate had. And I think she was talking about like them making alcohol or like jail wine or something like that. So.
Right. They get extra credits if they get, you know, if they take and graduate certain courses in the prison on behaving, on financial literacy, on education.
The landscaping that you mentioned, yeah,
typically result in them getting extra days off their sentence. So as I say, quite a few states got rid of the Parole Commission. Well, then there was lobbying in those states by people who said, well, wait a second, maybe there should be another review of the sentence involved. And so in states that got rid of their Parole Commission, some of those states passed a Second Look Act so that judges could take another look at those sentences, which now the inmates could figure out what their release date was from the very first date they went in if they did everything right, and they wanted to have an incentive to get out earlier. So some of those states said, well, you got rid of the Parole Commission in this state, so let's have, after a certain amount of years, a judge be able to take a second look. Now let's talk about Maryland. Maryland, to start with, after a judge sentences, automatically, in just about every case, has 2 reviews of the sentence by judges. The first occurs because every person sentenced can ask the judge to reconsider his sentence up until 5 years after he imposed it. And if a lawyer doesn't ask the judge to do that, then he's considered incompetent and the court will allow it anyway. So every inmate who gets sentenced, I mean, every convicted defendant is not subject to the judge saying, oh, I had a bad day today, I got in a car crash, and I'm going to give everybody a high sentence. The judge has 5 years in every case to think about whether the sentence was the appropriate sentence. And by the way, that's after reviewing guidelines issued to him by the Maryland Sentencing Commission, so he knows what the average sentences are. And then in addition to that judge reviewing the sentence, the convicted person can ask for a 3-judge review of his sentence by 3 other trial judges who were not his trial judge to see if they think the sentence was inappropriate. And most inmates do that. Some don't, because those judges also have the ability to raise the sentence if they think the judge was too easy given the crime that was committed. So some choose not to do that because those three judges can raise the sentence. So every one of those convicted persons has those two sentence reviews by judges, has the good time credits that they know they can earn, and also in Maryland has a parole review because there's still a Maryland Parole Commission. We are not a state that got rid of the Parole Commission. So why is there lobbying for another review after 20 years, and who are the likely beneficiaries? Well, to start with, there aren't that many sentences in Maryland where, given all the good time credits an inmate gets, you serve more than 20 years. And in fact, of those people who serve more than 20 years, they will, by that time, almost in every case, have been considered by the Parole Commission and denied parole. So who are we talking about that can benefit by this, quote, Second Look Act? It's not nonviolent felons. In fact, it's almost exclusively murderers, first-degree murderers whose sentence did not expire because of good time or who were denied parole by the Maryland Parole Commission. Those people, and there are allegations, oh, well, they're only in there because of racial disparity. That's baloney, because in almost all of those cases, the victims, the prosecutors, and the judges are of the same race as the defendant. He's committed the crime in his own community, which he has made less safe by virtue of his crime. So now what these people are lobbying for, these inmates and their supporters, is that people who've been in jail more than 20 years and not been paroled, namely almost exclusively first-degree murderers, should be able to go back to what turns out to be a new judge and go back three chances at least to a new judge and ask for a new lower sentence. Again, as right. Joanna said, why is it a new judge? It's a new judge because 20 years later, almost all trial judges have retired. I don't know that they're on the bench more than 10 or 12 or 15 years, but because judges don't get appointed when they're 20, they get appointed after having had a history of being a litigating lawyer. So most judges, trial judges, are going to be appointed in their late 40s and 50s, and they're not on the bench after they're 70. They've retired. Right. So the result is you wind up in front of a new judge who's been appointed, who really doesn't have any first-person familiarity with the defendant, and how nasty they may have behaved or looked, and how resistant they were to society's norms at their original trial and conviction. And this judge was not there when the victims, around the time of the original trial, stood up and gave their victim impact statement and explained how their life was completely turned upside down. So the result is they want 3 more chances to come back in and tell the judge, oh, they're fine now because having been in jail for 20 years where their opportunities to commit a crime are much less because they're locked in a cage and they're being watched with cameras 24/7 so they don't commit misconduct, that those people, because they've behaved in that while watched for 20 years, that means they're a good risk in society where there are no restrictions on them, and they should be released even though the Parole Commission has denied them parole. Now, they don't say that, even though the Parole Commission denied them parole. They want the public to think they've never been considered for release. And that is mostly, probably in 99% of the cases, not true.
And so, Victor, when it comes to like the judge versus the Parole Commission, right? And this is something that I'm almost a lawyer at this point, almost. So just knowing that we sued the parole commission and knowing that these things existed is not new to me. All of these qualifications that they have to kind of review. Does the judge have to look at those same things? Because he gets to look at whatever he wants, right?
Well, the judge has factors to look at and make findings about. But here's a key difference between the judge and the parole commission. The parole commission, as part of its regular job, always is looking at the back end of a sentence. They are always evaluating all of these factors and how the person behaved when they were in prison. And they have experts who help them do that. And that's their bread and butter. That's what they do thousands of times a year.
Right.
What a judge normally does is he looks at your behavior at the time of sentencing in the short time before you've been in prison. He doesn't have any expertise or training or experts to help him evaluate whether it is really meaningful or not that you behaved in prison. And he doesn't have any psychological staff that he can call on to say, well, this person had something that happened to him right before the crime, and that's why he did it. So you're looking at somebody, when you look at a judge, who is used to imposing a sentence at the front end of a prison sentence and does not have the training or experience that the parole commission has to decide what to do with somebody at the back end of the sentence after 20 years. That is what they do on a regular basis. That's what they're trained to do. They couldn't do the judge's job of deciding on what evidence should be admissible and how to instruct the jury. That's not their job. That is the judge's job, but it's a different job than looking at a person who's been convicted and in jail, typically for murder, for 20 years. And that's why we have the parole commission and why there are not just one parole commission member, but a whole bunch of them with different backgrounds who get to hear from the victims and the defendant and reach a consensus decision. That's not what happens under these proposed statutes. They want to go back. They call it second look, but they're ignoring the immediate. They're ignoring the immediate sentence options the defendant has to ask the judge to reconsider his own sentence, and the three judges in that court will reconsider it, all at the front end of a sentence. And they're ignoring what the parole commission's expertise at the back end. They want us to forget that the state of Maryland is spending millions of dollars every year to have this parole commission and its staff review all these cases. And they want to let one person who is new to the case, and typically, and I know because I've handled some of these, when you say to them, would you order a new pre-sentence report? They say, no, I've got the one from 20 years ago.
Right.
And they want to act based on that 20 years down the line and reduce the sentences. If we didn't have a parole commission, or if the judges were trained to look at these and saw them more than once in a great while, or if they applied to people other than murderers, that might be a slightly different situation. But that's not what this, and I'm going to call it fake second look act, is all about, because it is not a second look. If you count what the judge can do at the front end and the parole commission can do, many of the cases I'm seeing have been denied parole once or two times before their 20 years is up and they're eligible.
Right. So now we're talking about that additional, and we're going to get into the toll on victims here in a second. And I think that, just knowing that parole commission, I didn't know that the other states didn't have it. So that's definitely interesting. That's news for me. But almost a lawyer. So the parole commission and then the second look. Can we go into the current bills? Joanna and Victor had mentioned earlier that, this is not the first time we've seen these second look bills, but we want to make sure that we're pushing the information out, like this parole commission and how Vic explained, how things are going on and what they're trying to look at. But we want to make sure that people are aware of these bills, these new bills. Let me just try to figure out how to, oh, crap. Sorry. New thing. Oh, here we go. Okay, here we go. let's hop right into this. Okay, HB 853.
Well, I can only say when one of the criteria as the person is not a danger to society if released, that's a subjective decision by a judge. There's no objective criteria. A judge can say they are a danger or they're not a danger. And the judge doesn't really have to rely on much, even if the person committed a lot of offenses while in prison, which is rare because, again, they're locked in a cell and they're watched 24/7. A judge can say, well, I think that was because somebody else started up with them, or that's been a year or two down the line. So a judge is always free to simply reach a conclusion without having any particular strict guideline other than the judge's discretion. So although there are a bunch of factors, the factors don't dictate the outcome, and the judge can do what they want. And to be honest, there's a lot of sentiment that's been expressed from lots of the citizens of Maryland who think that 20 years in jail is sufficient, which for any crime, that a person must be different, which indicates, and I think there are many judges that we've seen, some who say, as soon as the case is brought to them that they have the authority to resentence after 20 years, they release the person on time served and probation. And they say, well, if they commit a new crime, maybe a new murder, well, we'll arrest them again for that, hopefully, and convict them then. Well, that's not really a great answer. And we have some experience because Maryland passed a bill that allows judges to do that to people who committed the crime before they turned 18. Now, that's a special case. That 18-year-old red line was drawn by the U.S. Supreme Court. But in Maryland, the supporters of this bill want to say, oh, people up to age 25 are really not so mature. They're just like people up to age 18. Well, frankly, I think it's kind of silly because people know by age 15 that murder is a special crime that you don't commit lightly, that before you take somebody's life, before you decide you are, prosecutor, judge, and executioner, you better know, you better think really seriously about it. This is not like shoplifting. This is not even like some kind of fraud. These are murderers who are in jail after 20 years and their sentence hasn't expired and they haven't been paroled. And that's something that is not lightly done in any society. So the argument that the people up to age 25, they still don't have a completely developed brain. Yeah, that's what science says, but it says their brain is 99% developed, and it doesn't mean it affects their behavior any. I guess I could tell you also that their ears and their nose haven't stopped growing either, but that doesn't mean you won't recognize them. So
where is HB 853 right now as far as legislation?
So I can talk about that quickly. So House Bill 853 was introduced in the House. It was passed by the House and sent over to the Senate. Yesterday, there was a hearing in front of the Senate Judicial Proceedings that we were present, and many supporters and families of homicide victims were there. We had a really great turnout, and we had a hearing in front of the Senate committee. And so now we are waiting. The Senate committee will be voting on it possibly in the next few days, if not sooner. If it passes out of the committee, it then goes to the floor of the Senate. If it has no amendments, any changes from its version in the House, then the Senate passing it will then pass the entire bill. If there are amendments, however, then it has to go back to the House to determine if the House will pass the bill in that same amended version or not. So I do want to, we have kind of the very basics up here of what this bill includes. And it is that any defendant who has served 20 years of a sentence, regardless of whether it says the sentence is life, and that is true. The only exceptions here, the only people this does not apply to are those serving a life without parole term or who are also on a sex offender registry list. So there is murderers first degree are qualify for this. There are also what we found learned yesterday when the proponent of the bill was speaking is that although there are these restrictions, they believe that they should get a second look as well. And so we were very, very concerned to hear that basically they think every crime, 20 years is enough. And I think that's very sad because it's not considering the loss to the crime victims, that they're never going to see their loved one again. And these are not people who are sentenced to a 20-year sentence. To really be still in jail past 20 years, you had a 40-year sentence or longer, because they get basically 50% off of their sentence due to good time, what we would colloquial call good time credits. And so these are people that committed very serious crimes that were supposed to be in jail to give victims thought that this was a for certain thing, that this was going to happen, understanding they weren't even going to serve their full sentence, but they would at least be there for 50% of that sentence.
Yeah, and I think that, that's the concerning thing about this, is that this is someone who has been sentenced for over 20 years. So they could have been sentenced for 40 years or 60 or 80 years. And now we're talking about every 5 years they are bringing the family to court.
Yes,
again,
and I
want a second. Because that's definitely, I definitely want to talk about that emotional, toll.
Yeah, let's turn it to Dawn, but I think also to point out that this isn't just one hearing. They actually could bring the hearing 3 different times every 5 years.
Every 5 years, right. So let me let's fly through this other bill, and then we're gonna.
We don't need to talk about the other bill actually, because it did not pass out of the committee. So.
Oh, perfect. All right. So there's one less thing that we have to talk about. So I'm going to go ahead and remove this screen. Let's figure out how to do this. There we go. Okay. So we just talked about all these things. You saw the video with Joy, which, was telling, because that was a parole commission hearing, right? For the one for Joy. And we've got Miss Dawn Collins here, whose son was murdered. And we're very familiar with her. She has turned a fierce advocate for victims. And we're just so proud of the things that she's become empowered to do. But I mean, I think in our job, we hate to meet people this way. It's the worst way to meet people. I mean, it really is, when they're just at this place. But let's let Dawn tune in. Dawn, what do you think about all this? And what are you?
I'm flabbergasted, because in all that I've heard and all the hearings that I've been, not one time did I hear anyone say anything about the victims and survivors. To me, no one thinks about the emotional toll that it takes, that you live this tragedy every day of your life. I've spoken with mothers from across this country, and I can tell you, I've not had one of them say to me, "Oh, you know what, Dawn, I'm over that. I'm okay. That was a mishap and they deserve that. And my loved one really didn't matter." I actually sat in a hearing and heard a person say, "Well, I deserve a second chance. Don't I deserve hope?" And it took everything in me not to jump up and say, "Are you kidding me? Where's my hope? Where is my second chance? Your second chance is that you're still living. I have to go to a cemetery and speak words that I can't fathom any mother having to speak." And hearing people say, "I deserve." Then I hear, "Well, it's more blessed to forgive." Well, I also know that there's a commandment in the Bible that says, "Thou shalt not kill." Simple. Simple.
Yeah.
It doesn't say, "Well, maybe you should." No, it says, "Thou shalt not kill," period. And to say that someone's brain is not developed and they really don't understand what they're doing, I'm not going along with that either. You can drive a car at 16. You can defend this nation at 18. So really? And I'm saying we need to understand the victims and the survivors. And I am saying to all legislatures, take time, sit down, speak with the victims and the survivors, hear their stories, hear their hearts, because oftentimes no one takes the time to hear them. What you're often given is platitudes. Well, our thoughts and our prayers are with you. Go forth. No, doesn't work like that.
And I've seen you guys have just been going to Annapolis trying to battle these bills. And I think the one thing that's really tough is when the room is filled with people that are for this bill. And they're fighting for these bills, and it's like the squeaky wheel, right? So those are the ones that are getting the ear at that time. And then there's a few that are able to come, for us. Could we fill that room? Probably. But we also are talking about people who are tired.
Correct.
They're tired. They're emotionally
Broken.
broken. They're emotionally broken. And I've heard of some of our most avid supporters, one in particular who was re-traumatized by going to Annapolis. I mean, these are not easy things for people to do. And in our office we always say, people are, when they're ready to tell their story, when they're ready to talk, if they're ever ready to help another person, if maybe so, because everybody has a different journey, after the fact. But it's hard. I know, for me, I don't work as closely as Joanna and Victor do to get attached to people. I try to come in when they're kind of ready to receive, what I'm doing, separately. But I think that's the hard thing. And so how else do we battle if we're not in that room? What do
When
we
you speak about re-traumatization, and real quickly, there was one of your persons that you represent. She was sitting in there hearing those testimonies, and the murderer of her son came in to testify. Again, re-traumatized. And she was like, I can't believe he's in here speaking about his second chance.
And I think what was most notable about that is he never mentioned what he did. He never spoke about his regret, because there were a number of people who had been released under the version of this bill that applies to those who were convicted as adults but were under the age of 18. So usually 17 and 18-year-olds who committed first-degree murder. And so our client was one of those, and whose defendant had been under the age of 18. And yeah, he showed up. He said nothing about the crime. None of these defendants who came and spoke said anything about the crime. They just said, oh, I'm doing so much better. I've got this, they've been out for a year.
How great it is. Yeah.
Yeah. And it was very, very traumatic for our client.
And I know Victor went to the last court case for that one. And I think that Victor might have gotten in trouble. I think, which is not uncommon for Victor because he's so sharp and he lets them know. So what do we do now? We need to stand up, and we need to make sure that we're standing, aligned with victims, and each victim is different, right? There are some people that are in a different place as far as what forgiveness looks like and how that feels and how they move about their lives. But we always want to make sure that we're standing with the victim and their survivors in this. And how do we do that when it comes to these second look bills, especially now, knowing there's a parole commission there and there's resentencing. So you're literally going, what, Victor, 3 times, and then every 5 years, and then what does that look like? What does court look like? A lot, right?
It's a lot. It's very intensive. It's a lot of time. It's a lot of effort. It's the stress of knowing those court dates are coming up. So we're not just talking about one time the victim has to go. And the proponents of this bill always talk about, well, they don't have to go. And it's like, yes, but if they don't go, nobody listens to their voice. They only hear from the defendant. They only hear what the defendant wants. And I've just seen it time and time again in court that if the victim does not show up, they do not get the same attention and respect that they deserve and that they would get if they show up in person. And even then, if they show up in person, sometimes the judge still does not take their opinion into account. But that's the first place. But I think when we're talking about what do we do now as far as this bill, what is our call for action, and what we're asking people to do is we need people to show up in Annapolis when we do have these hearings. And we've had a much better showing this year. It's been really great. But now we need people to call their senators. So what we're doing is asking you, and we're going to put this link in the chat so that we can so that you can go and find your senator. You might have several senators for your county. So please do that and call them up and tell them that you oppose House Bill 853 and why you oppose it. And then one more request is that the president of the Senate, Senator Ferguson, is apparently a proponent of this bill, which is very disappointing. But what we're asking is that people will call his office as well and let him know that you are opposed to this bill. So you see, we just put the link has been put up. It'll tell you, you go in, all you got to do is put your address in. You can see that on the screen here, and it's going to let you know who are your delegates, who are your senators. But the important part at this point is to contact your senators, please. There's a lot of people who want to get their loved ones
Do
out of.
we have the state bill? It passed House and it's in state now, right? Is it a
It's
different
in
bill
it.
number?
It's in the Senate, but it is House Bill 853.
Okay. Sorry,
Yeah.
I got confused.
So it keeps
And then
whether it's a
Senator
House bill or a Senate bill
Ferguson?
is determined by who introduced it.
You said Senator Ferguson? I'm sorry.
Yes, Senator Ferguson is the president of the Senate. Yes, so we're posting that as well. Thank you. And so that's really our call to action, because we need people to have their voices be heard. And the best way to do that is by phone, to let these members of the legislature know that we want to protect the innocent in Maryland. We want to protect those who didn't go out and kill other people. We don't need more violent offenders on the streets. If anything, Marylanders have been talking about their concern for the crime rates in Maryland. And what we know is that when people are released for prison, there's a term, it's called recidivism. And people often go out and commit more crimes. And the crimes that they commit are usually follow in line with what they were in prison for. So violent offenders are more likely to come back and commit more violent offenses. And so that's the concern. When you look at, and it's you're going to hear certain things from the proponents of this bill. They're going to talk about Maryland's recidivism rates. Maryland only looks at the first 3 years after a person is released from prison, which is a very short amount of time, and usually a time when they are still under parole and probation. And there's certainly recidivism at that point. And it's still quite high, in my opinion, and it goes down as people age. But even for people 60 plus, it's over 10% of them are going to recidivate. But when you look at more thorough studies, in particular the Bureau of Justice Statistics, which is a federal run by the FBI and through the federal government, they track for numerous states, and they look at over 5 years, because they do not consider 3 years to be sufficient. Often places will look at 10 years as well, because it's not like the person only lives for 3 more years, right? They have a whole lifetime. And so the important thing is to look at who else is suffering and who else is a victim, because we let these people out of prison who have already traumatized a family. We don't need more traumatized families. And so that's our concern. And when you look at that for violent offenders, it's over 50% the rate of recidivism. And so we're very, very concerned for the state of Maryland with this current push to let everybody out of prison, regardless of being the worst offenders, having done the ultimate crime of taking someone's life. Very, very bothered by that. So we're asking people, for everyone who also believes that, no, if you commit first-degree murder, you should not be getting, I think we counted up, and we counted at least 16 different ways you can reduce your sentence, challenge your sentence after you are convicted by a jury. And so this would really be a 17th look. So
Right.
we're asking.
And I think the important thing with this particular bill, is it's for people who have been sentenced for over 20 years. Like, what can't be lost on this is it's not just a second look. It's actually for people who have committed the most heinous crimes, in that, so much so that they were pretty much put away for over 20 years. Like, the original judge thought that 20 years would not do this guy a thing.
And one of the other things that needs to be pointed out is, if they were convicted before they were 25 and they've served 20 years, you're releasing them in their early 40s, not in their 50s and 60s and 70s, but in their early 40s. And the recidivism data for people in their 40s who've committed violent crimes like murder, that is the highest category, according to the U.S. Sentencing Commission, for people to commit a new crime.
Wow.
Yes.
Okay. All right. So a lot to act on. To our friends at home, we know that you're following us because we see, but we really are trying to make sure that we're activated, particularly on this bill. I think a lot of information was provided here. It'll be recorded if you want to share this, if you want to make sure that they're. And when do we think they are voting? I know it's by I think last day 7th, so it has to be.
Right. So it's our understanding it'll likely come up to be voted on in the committee in just the last couple of years. I'm sorry, next couple of days. And then it would go to the Senate, and the Senate will have until April 7th, when the legislative session ends, to pass it. If it's amended, it still needs to go back to the House and be passed there as well before April 7th. So that's why we're trying to stop it here in the Senate and get as many people to call your senators, all of them, and call Senator Ferguson, the president of the Senate, as well, please.
Right. So call, email. We're really trying to get this stopped so that it's one less battle. It's one less trauma. We already have a parole commission. Let them do their work. Let them do what they do. All right. Parting words before we hop off.
My parting words are, if you find it difficult for you to make the call, if you find who your representative or your senator is, you can click on it and send them an email and tell them you oppose this bill, the Second Look Act. So even if you don't feel comfortable making a call, please send an email to that senator, because they will read that, or their staff will as well, and they will count those.
Yes, and ask your family members and friends to call as well, please.
I will say, ask family members to call, but please don't forget the victims and the survivors. They live this every day of their lives.
Thank you, Dawn. Yeah, I don't know how to follow up any of that, but join our mailing list, see what we're up to. I know that the emails have been a lot lately. We're very we feel very strongly against this bill, and so if you've gotten a bunch of emails, it's not our norm. We usually like to send like one newsletter a month, but this time we kind of had to fill those boxes because it's just that important. You can message us on social media, you can email, you can do all the things. You can also grab our newsletters on our website. So make sure that you're keeping abreast to what we're up to. We'll make sure that we do a social media update when we find out how all this pans out. But we're trying to put up a good fight, and we need your help. So thanks for tuning in. Thank you, Joanna, Vic, and Dawn, for joining us. And hopefully we'll have good news for everybody in the coming days. So
Thank you. Bye-bye.
thanks, guys.
Thank you.